Hello friends, in continuation to earlier two talks on the office of the governor, first of all, let's take up the legislative powers. The governor is although not a member of the state legislature, but he is considered as an integral part of it. He has the right to address the state legislature. The other important legislative power of the governor are: number one, nomination to the state legislative assembly and state legislative council. The governor has the power to nominate one member from Anglo-Indian community if he feels that there is a need for such representation in the state legislative assembly as per the 23rd Constitutional Amendment Act 1969, which was made effective from the year 1970. The governor is also empowered to nominate 1/12 members of the legislative council of the state from the persons who have special knowledge and practical experience in literature, science or arts, etc. The legislative councils are there in Andhra Pradesh, Bihar, Maharashtra, Tamil Nadu, Telangana, Uttar Pradesh and Jammu and Kashmir. Number two, power to appoint speaker and the deputy speaker of the state legislative assembly and the chairman and vice chairman of the state legislative council. The constitution has provided the power to the governor to appoint speaker and the deputy speaker of the state legislative assembly. He is also endowed with the power to appoint chairman and the vice chairman of the state legislative council to take charge in case of emergent situation if the office falls vacant due to some unavoidable circumstances. Number three, governor has the power to summon the session of the state legislature. As per the constitution, or we can say the constitution has empowered the governor to summon the state legislature in consultation with the chief minister of the state. However, it is ensured that more than 6 months should not have elapsed between the two sessions of the legislature, that is, the last day of the sitting of one session and the first day or the beginning of the legislative session of the next meeting. Article 175 of the Constitution provides for summoning a joint session of the two houses, and the governor can address both houses together. It cannot be made effective when President rule under Article 356 is imposed and Legislative Assembly is in dissolved stage. It is not a power, rather a responsibility or the duty of the governor. Number four, prorogation of the legislative session. It is a convention that while proroguing the house, the governor must consult the chief minister and council of ministers. However, it has not been followed in a religious manner. The governor uses this power judiciously or as per the suitability or the political suitability. The governor may refuse to prorogue or accede it to favor a chief minister if likely to face a crisis of confidence of the legislature. Number five, power to promulgate ordinances. As per the provision made there in Article 213, the governor has the power to promulgate ordinance as per the advice of the chief minister and council of ministers when the state legislature is not in session in order to deal with an emergency requiring immediate action. The ordinance has the same force as the law passed by the state legislature, but it ceases to operate after 6 weeks from the assembly of the legislature or before the expiration of that period. A resolution disapproving of it is passed by the state legislature. the governor can withdraw an ordinance at any point of time. It is also important to note that in certain circumstances, the governor promulgate an ordinance without instructions from the President. The circumstances are: number 1, if a bill comprising with the same provisions requiring the prior permission of the President for its introduction in the state legislature. Number 2, if the governor need to reserve a bill containing the same provision for the consideration of the President. And number 3, if an act under the same provisions would have been reserved for the consideration of the President and would have received his assent. Number 6, dissolution of the House or dissolution of the State Legislative Assembly. In case the government is not backed by the majority, then the advice to dissolve the House is not binding on the governor. The governor can also order dissolution of the State Legislative Assembly under Article 356. It can also be dissolved if the Council of Ministers resigns without passing the budget. Number 7, assenting bills and reservation of bills for the consideration of the President. A bill introduced in the state legislature, debated and thereafter passed with requisite majority is presented to the governor, who either gives his assent or sends this bill to the legislature for reconsideration. The governor is not empowered to veto a bill, but the governor can delay an enactment by reserving a bill for the consideration of the President, if in his opinion the enactment of such law may endanger the position of High Court by derogating its powers assigned to it by the Constitution as there in Article 200. Further, the assent to a bill may be withheld if bill passed by the state legislature is unconstitutional or against the larger interest of the country or indirectly opposing the directive principles of state policy or deals with compulsory acquisition of property under Article 31 Clause 3. So, these are the important legislative powers assigned to the office of the governor. Now, let us discuss about the financial powers of the governor. The Constitution under Article 202 provides that a money bill cannot be introduced in the state legislature without the recommendation of the governor. He ensures that annual financial statement of the estimated receipts and expenditure of the state and referred as annual financial statement be laid down before the house or houses of the state legislature. The contingency fund of the state is also at his disposal and allows meting out the unforeseen expenditure of the state from this fund. So, this is the financial power, which is again a nominal one. After discussing the financial power, let us take up the judicial powers of the governor. The Constitution endowed the office of the governor with the power to grant pardons, reprieves, respites, or remission of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence against any law relating to a matter to which executive power of the state extends. Means, this can be, the judicial powers are within the jurisdiction of the executive powers of the state, not of the union government. This kind of provision has been made there in Article 161 of the Constitution. In other words, we can say that the power of the governor is restricted to the matter on which the state legislature has the power to make laws. The power entrusted to the governor is not a prerogative, rather a constitutional obligation. The Supreme Court in its decision Shatrughan Chauhan versus Union of India in 2014 expects that the mercy petition be decided in reasonable time and it should not be at the discretion of the executive, as the objective of conferring such power is to have an opportunity to correct judicial errors and provide relief from undue harassment evident in operation of law. Therefore, it is the constitutional responsibility of the governor or the office of the governor to take a decision in case of this kind of the judicial power. Next, we have certain emergency powers also. And what is the position of the governor relating to those emergency powers? Let's have a brief discussion on this issue also. The Constitution has provided for certain emergency power in 3 different articles, that is Article 352, 356 and Article 360. It is under Article 356 which calls for substantive role of the governor in imposing president rule in the state. He has to submit a report to the president stating that he is convinced based on facts mentioned in the report a situation has arisen in which the government of the state cannot be carried out in accordance with the provisions of the Constitution. The report, which is based on facts, facilitates the president to make proclamation under Article 356 and ask the governor to assume the functions of the state government. The power provided under articles have been used or misused more than 100 times in India, and the expected dead letter provision in Article 356 has been made as a deadly weapon against the state government. In a significant decision known as S.R. Bommai case decision and later in Rameswar Prasad versus Union of India case, the Supreme Court held that the dismissal of government and a dissolution of assembly in many instances were found unconstitutional and laid down certain principles to be followed in such situations. Thus, the role of the governor is significant only in case when president rule is imposed under Article 356. It may not be so important in case of Article 352 or Article 360. Let's discuss about the power exercised by the governor independently. The governor office is also endowed with certain powers which he exercises independently and himself, and these powers are: number 1, the governors of Andhra Pradesh, Assam, Manipur, Meghalaya, Mizoram, Sikkim, Tripura have certain discretion in administering the tribal areas of the respective states. Number 2, the governor has an important responsibility to examine and report the situation indicating failure of constitutional machinery in the state, which he does independently and report to the president. Number 3, the governor can also reserve a bill passed for the consideration of president by the state legislature, not only those which he constitutionally obliged to do, but any other also on the plea that it is not in conformity with the union bill. Number 4, the governor seeks guidance from the president before issuing an ordinance. It is not independent, but not an act performed as per the conventional advice of the Council of Ministers of the state. Number 5, the decision to dissolve state assembly is as per the recommendations of the Council of Ministers. But in case the government of the day lost its confidence or the majority in the House, then the governor takes the decision as per his own assessment. Number 6, governor allows the prosecution agency to initiate criminal proceedings if required against serving or former chief ministers, if so demanded by the concerned agencies. Number 7, sometimes governor is also appointed as the administrators of the union territory. In case of such appointment, the function of the additional responsibility are performed independently of the conventional advice system. So, these are the powers, these are the 7 powers which governor exercise in an independent manner. Lastly, let us discuss about certain miscellaneous powers of the governor. Number 1, the governor is empowered to receive and table the report in the state assembly or the state legislature of the state finance commission. Number 2, he is also empowered to receive and table the report in the state assembly or the state legislature of the state public service commission. Number 3, he is also empowered to receive and table the report in the state assembly or the state legislature of the state auditor general. Number 4, he also acts as the chancellor of the state universities and appoint vice chancellors as per the procedure established in that particular state or university. Now, let us sum up the discussion on the office of the governor. In these talks, we discussed about the manner in which the governor is appointed, the qualification required to appoint a governor. We also discussed about the tenure and transfers, oath and privileges. We discussed about the executive powers, legislative powers, financial powers, judicial powers, and miscellaneous powers, along with the powers where he exercises the powers in an independent manner, that is without the advice of the Council of Ministers. We found on the basis of the powers assigned to him that since the governor has to act in accordance with the advice tendered by the Council of Ministers headed by the Chief Minister of the state, most of the times he is acting as a nominal head, but there are many instances where the governor can act as a constitutional head, as a representative of the union government, or as an agent of the union government. In actual, it depends upon the political situation, that is, which party is in power at the union government level and the party in power at the state government level. You will find there is a tendency of conflict if the government at the two levels are of different political party or the political party having the different kind of the ideology. But in case if it is of the same political party, then the office of the governor is utilized to work together, that is the union government and the state government, or we can say the union government has an effective influence on its state government. So, with this discussion, I hope you have been able to understand about the office of the governor and the power exercised by the governor. In the next theme in this course, we will discuss about the chief minister, definitely how he is appointed, and also the powers and functions of the chief minister. Till then, I would like to suggest to you that you go through the e-text as well as the resource in the form of books, articles and the web links which are provided to you and try to understand the real situation or the real position of the governor. In that resource material, you will find so many examples where the governor have been transferred or additional responsibility of another state is assigned to them, where the president rule is imposed under Article 356 and many more things. I hope that by this discussion you have been able to understand about the office of the governor and his position in the constitutional context and his position in the government. So, next time we will discuss about the real head of the state government, that is the chief minister and the council of ministers. Till then, wish you a very happy learning and see you again. Thank you very much.